Okay, I can see people are still joining, but I think I will kick us off now. And by the time I've done the intro, most of those people should be on the online and listening in. So good morning, everyone, and welcome to today's webinar, Defective Lease Issues in Conveyancing. Delighted to be joined by both Steve Johnson from CLS, but also by Chantel Wren from CLS as well. And the idea of today is to help solicitors navigate the complexities of defective lease issues and the insurance solutions that will help property transactions progress. So I'm just going to hand straight over to Steve to kick us off onto the webinar itself. Steve, good morning and over to you.
Thanks very much, Adam. Good morning, everyone, and thank you for joining us for the latest webinar from InfoTrack, and my thanks to them for hosting this course on defective lease indemnity policies. I'm Steve Johnson of CLS Property Insight. As you may have seen from the invite, we had the name of Roy Goodman as the original presenter, but unfortunately Roy's unavailable today, so I'll be taking you through the course content. If you do have any questions during the presentation, please do send those in line with the advice that Adam gave a little bit earlier. And just to let you know in advance, you'll be getting towards the, just after the presentation, the slides and of course contact details for any further follow-up that you wish to undertake. Now, many of you will be familiar with CLS, having accessed our policies through InfoTrack, but for those that aren't, I should probably mention that our legal indemnity policies are underwritten via Great Lakes Insurance, with whom we have a long-standing relationship. The security ratings for Great Lakes are A+ superior, as rated by AM Best, and AA very strong by Standard & Poor, and these are one of the highest security ratings available in the UK market. It's probably pertinent to also mention that we have one of the highest capacities in the marketplace, which is currently at £250 million. Now, during our short time together this morning, it's my intention to provide you with a better understanding of our standard defective lease indemnity policy, together with a brief overview of how you can obtain this. So let's begin taking a look at the following topics, which we'll cover this morning. Firstly, we'll look at what is covered under a defective lease policy. In this section, I'll explain what cover is provided, and we'll also provide you with some practical scenarios of how the policy might be called upon. We'll also look at what is not covered under our policy. Unfortunately, our policy can't cover all eventualities, so I'll run through the specific exclusions contained within it. We'll look at what can be insured, what is the period of insurance, and what information is required from you. And here we'll look at the statements of fact you'll be required to confirm before cover can be affected. We'll look at how you obtain a policy, and obviously how CLS Property Insight react to market change and changing policy requirements. And then we'll close with a look at an example of a recent real-life claim. Well, firstly, let's look at who is insured. Ultimately, our policy's intention is to protect the purchaser, the lender, and their successors in title against potential defects contained within their lease. These defects are typically identified by yourselves and could potentially cause a financial loss. It's important to note that insurance is for a continued use single residential leasehold flat or maisonette as constructed at the inception date of the policy. It should also be noted that we can offer defective lease policies for commercial properties, which can be ordered online via InfoTrack. Please refer to our online contingent buildings policy as well as our absent landlord policy. So let's start the first section of our presentation by looking at what is covered under the policy. And firstly, the insured is unable, the cover is provided where the insured is unable to enforce rights or obligations in the lease for repair and/or maintenance of a building. Examples that we have seen have been leaseholders trying to enforce a broken front door to a property that has 2 flats within it. We've also seen claims where water ingress from a damaged roof has damaged communal parts of the building. And while this has technically not touched the insured leasehold property, the effect has been on the value of the property, and this, of course, has been a concern. Secondly, there is cover provided where the insured is unable to obtain appropriate contributions or reimbursement of costs of repair and maintenance of a building. A recent example saw a recent flying freehold matter where a policyholder had had very little joy contacting the neighbouring freeholder who was liable for a share of repairs. When we were notified of a claim, our panel solicitor was able to rouse them from their slumbers and quickly arrange contributions from the neighbour. In this instance, we also saw a contribution from the policy to get the repairs completed at a challenging time of the year. In addition, the policy also covers where the building of which the property forms part is not repaired or reinstated because the property's insurance provisions in the lease, A, are not compatible with the requirements of the latest UK Finance Mortgage Lenders Handbook, B, are inadequate or provide for an insufficient amount of money, C, are reduced through an act or omission of a third party, D, cannot be enforced due to the insured landlord being absent or in receivership, and E, cannot be enforced due to a lack of inadequate support, protection or mutual enforceability clauses. And this element is not dissimilar to a standard standalone contingent buildings cover, and the absent landlord issue is the one that crops up more often than not, where the leaseholder seeks contributions for damage caused by, say, a fire, which would have fallen under the obligations of said landlord. Another example is that should the property collapse and the building's insurance held by the landlord be sufficient, the leaseholder may suffer loss as the building of which the property forms part cannot be repaired or reinstated. The policy will also provide cover where the purchaser does not have a documented legal right over the common parts or over a defined route in existence at the inception date. We've actually experienced this scenario where a policyholder unfortunately woke up to find the neighbour had built a log store in front of their back door, and the policy was able to come to their aid and challenge the neighbour by asserting a prescriptive right. Now, these two go together quite nicely as a pair. You have, firstly, there may be a scenario where there are missing or illegible pages in the lease, and then maybe the plan referred to in the lease, once again, is missing or is uncoloured. And missing or illegible documents crop up as claims. Missing information such as this has caused more than a few issues in the past. We had a tricky case just last year with a policyholder who thought she had a private garden, but the neighbour came forward with a document that proved she had a written right to cross the garden via a set of steps to the rear. Another difficult claim we've seen is from a couple of years ago, which involved a neighbourly dispute, or a rather unneighbourly dispute, where the two neighbours both wanted to park on the unregistered land in front of the two properties, and the uncoloured plan could have been interpreted a number of ways. Now, even with the policy paying for two councils' opinion, we were not able to convince the neighbour, and the policy ended up settling for a devaluation in the property value. The irony here being there was plenty of room to park two cars on the land, and as we know, unfortunately, often common sense with neighbourly disputes can slightly leave the building. Now that we've seen what is covered, let's go on to see what is not. Now, as with all policies, unfortunately, our policy doesn't cover all eventualities, and these would be some of the examples. You may have loss arising because you interfere or interrupt another person's use of the common part as defined in the lease. An example of this is where there has been an obstruction in the communal hallway, preventing a third party's access. Also, we would not cover you if there was a structural defect that was unknown at the time because you did not do a home buyer's report or a structural report at the inception date. There may have been loss arising as a result of the policy holder cancelling or allowing to lapse any building's insurance policy in respect of their property or the building of which their property forms part. In addition, were there to be loss falling within any excess or deductible application to a property insurance policy in force in respect of the policyholder's property, or once again, the building of which the property forms part. Where the building insurance has an excess or a deductible, our policy would not step in and pay this. In addition, our policy would not cover loss arising from damage or destruction of the policyholder's property, or indeed the property of which the building of which the property forms part, if it was caused by a peril ordinarily excluded from coverage in a building's insurance policy. The policy would only step in for any reasonable peril contained within a standard buildings insurance policy. As an example, we would not cover damage caused by civil unrest or a terrorist act. And then finally, if for any reason the property insurer were to go insolvent, this policy would not step in this particular instance. So let's turn now to the period of insurance. Now, unlike most legal indemnities, where the insured risk diminishes over time, our defective lease policy does not provide cover in perpetuity. It's actually limited from the inception date and continues for 25 years or for a period coextensive with the terms of the mortgage. Now, we hope that obtaining a policy such as this couldn't be simpler, subject, of course, to confirmation of the statements of fact you'll be familiar with. And these, of course, are all laid out on the InfoTrack ordering platform. For this particular policy, defective lease, there are, in fact, 7 statements of fact to agree to. And I'll start with A. Firstly, the property is a single leasehold flat or maisonette in England and Wales. Secondly, the building of which the property forms part is used entirely for residential purposes. C, neither the seller nor the buyer are aware of any problem relating to the structure of the property or the building of which the property forms part. D, the buyer's conveyancer confirms that the property is insured under a buildings or insurance policy or policies that are compatible with the UK Finance Mortgage Lenders Handbook for solicitors and licensed conveyancers. Now E, where the lease of the property identifies that the freeholder is responsible for insuring the entire building of which the property forms part, and the buyer's conveyancer has confirmed that the freeholder has confirmed that at the inception date there was in force, once again, a buildings insurance policy or policies that are compatible with the UK Finance Mortgage Lenders Handbook. Statement of fact 6, neither the seller or the buyer is aware of any disputes regarding maintenance or insurance arrangements of the property or the building of which the property forms part. And then our final statement of fact associated with this property, neither the seller, or with this policy, my apologies, neither the seller nor the buyer of the property are aware of any dispute regarding access over or use of the common parts as defined in the lease. Now, if you can confirm these 7 simple statements of fact, you're then able to access the policy pretty much instantaneously through the InfoTrack site. However, if for any reason you cannot agree with these statements, we can, of course, consider the risk, but on a bespoke basis. Now, if this scenario does arise, you'll be prompted to speak directly to one of our CLS Property Insight underwriters, and they'll be able to consider your risk on its individual merits. But please note that just because you can't confirm a particular statement, it doesn't mean we can't insure the risk, or in fact, that the premiums will increase. The statements of fact, as always, are a start point, and it's pertinent to mention that we pride ourselves on always trying to provide a policy. CLS Property Insight is recognised as one of the most flexible and supportive partners within the insurance market. Now, as an example of this, we were recently approached by a solicitor who is seeing more and more cases where certain pages contained within the lease were illegible. And at the time, our standard defective lease policy only provided cover in respect of missing pages. But the feedback from our client allowed us to reassess our coverage, and we extended our policy wording to include illegible pages of a lease. We believe our relationship with yourselves and indeed with InfoTrack is very much a two-way street, and we're always happy to discuss any aspect of our policies and when possible work together to provide a better or more suitable end product. Now, I mentioned as when we were going through the agenda that we would look at a particular claim. So here is an example of a recent and I think quite pertinent claim. This one actually relates to the contingent building element of cover, which is certainly a useful one to have. This is especially if there are potential gaps in the insurance provisions contained within the lease, or those provisions are inadequate for the proper protection of the property or are totally absent from the lease altogether. It's important to note that this particular element of the policy is not to be mistaken as a substitute for standard buildings insurance, which of course is your client's responsibility. Now, for this particular matter, the solicitor acting on behalf of the purchaser contacted us back in 2013 for a defective lease policy. And this was as a result of inadequate insurance provisions contained within their client's lease. An online policy was successfully obtained and the statements of fact were all confirmed. Subsequently, we were contacted by this policyholder following a fire at their leasehold flat in the Essex area. They'd initially contacted their landlord to claim through their buildings insurer, who had accepted liability for the damage caused by the fire. There was damage to the shed in the garden and subsequently damage caused to the toilet window, flooring and decoration throughout the property. They wrote to us to inform us that the landlord's building insurer were unable to cover damage to the render on the external gable wall, which was located above the shed. Now, once instructed, CLS claims handlers immediately needed to take a view on the coverage, and we instructed expert solicitors to assess the lease. They also looked at the situation with the freeholder before confirming that cover under the policy had indeed been triggered. Now, the instructing solicitor ascertained that the CLS Property Insight policy was required to step in due to the lease in question requiring the landlord to insure the premises. And when reading the lease, the premises, as defined, did not include the structure of the entire building. In this example, it was the common parts that the landlord was responsible for insuring. Importantly, that meant on the face of it that the landlord wasn't required to have had in place insurance for the exterior walls. Therefore, in this particular instance, the insurance provisions in the lease were totally inadequate, as the premises were deemed to be the common parts and the external parts did not fall within this definition. As I'm sure you're aware, it's very unusual for a landlord to be required to insure only the premises and not the whole building. Now, in the light of this, our claims handlers were then able to liaise with the building's insurer on behalf of the policyholder in order to establish quantum and in turn agree who was paying what. This was as a consequence of the building's insurance shortfall resulting from the definition of the premises. Now, following negotiations with the insurers, it was agreed who owed what to whom, and CLS Property Insight agreed to pay a figure of £3,000 for the works that fell outside due to the limitations of the landlord's insurance. This offer was accepted and a cheque was quickly sent, allowing repairs to be carried out. Now, the cover here was a blessing to the policyholder, who was not overly familiar with how insurance claims worked. And one of the things to note here is not just, of course, the financial recompense, but the expert advice that the policyholder was able to access through the policy that they'd taken out. And the CLS claims handlers were able to guide the insured through the process and reassure her that she would not be out of pocket through no fault of her own. All of this resolved for a one-off premium of £162.50. I'm sure you'll agree that the level of support and guidance provided resulted in a pretty positive outcome for all involved. So we're coming now to the end of the webinar. I certainly hope you found this helpful and in some part have helped clear up any questions you may have had in relation to our defective lease cover. However, if you've been posting any questions or you have any questions as a follow-up regarding the content of the webinar or anything else, my contact details and those of InfoTrack are on screen and we'd all be very happy to help. I hope it's been a useful session. Please do get in touch if any of the future InfoTrack training webinars are of interest. As you know, this is part of a program they are compiling. You'll receive a copy of the slides shortly. And at that point, Adam, I'd like to hand back to you and thanks all again for your attendance.
Thanks, Steve. Yeah, there are no questions. If anyone does have a question, there is a Q&A button at the bottom there. Otherwise, I will leave that screen up for the time being. We have recorded this webinar and we will place it into YouTube over the next few days. So just bear with us while we do that. Otherwise, I wish you all a great Easter weekend, or as good as it can be, being indoors or at home. And thank you very much for today. Thank you to Steve and to Chantel. Thank you. Bye-bye. Steve?